So welcome to the court. Court rise. Captain is here.
Court ready.
Good morning,
Good
Captain.
morning, Lily. How are you?
I'm doing awesome.
I like your energy this morning.
You
You
know,
always
I'm,
light
I'm,
to
I'm
fire.
always energetic. See, yes, I'm by me marrying him.
You.
Yeah.
It's very, very important. You know, happy yourself. You
New
know.
watch now, born so yeah. Anyway, what happened in court yesterday? Let's talk about it.
Yes.
SALL petition.
Yes, SALL petition. Yesterday, very interesting one at the whole High Court. Lawyers of the applicants, in fact, they petitioned the High Court. Everybody knew about what happened in 2020 during the election of John Peter Amewu. Certain people within Santro Kofi, Lolobi, and all that were restricted. They didn't vote. So as we speak, they are not represented. Their lawyers, well, there are 5 applicants, in fact, led by Professor Kweku. In fact, through Chachichikas are petitioning the High Court to annul that particular vote and declare that proper elections were not conducted there. For that matter, the election of John Peter Amewu should be nullified. Yesterday, the court determined the matter and said, look, what we are seeking is a provision in the Constitution that the Supreme Court ought to interpret and not the High Court. This is not an election petition. It's not a parliamentary election petition. This has to do with provision in the Constitution. Faisal Abdul Idris was at the court and he came through with this report.
After a protracted proceeding that started from 2021, the whole High Court has finally passed its verdict on the SALL case. The presiding judge, Justice Owehini Champo, before he delivered that verdict earlier today, indicated that the reliefs being sought by the petitioners are matters that border largely on constitutional provisions that only the Supreme Court has jurisdiction over. He indicated that for that matter, his hands are tied. He went ahead to dismiss the petition. The parties to the case have been reacting here at the court premises right after the verdict.
The verdict was given, and to God be the glory. It has just affirmed our long-held position that my brother, Honorable John Peter Amewu, has been duly elected by the people of GHOne. So, to us, it's a well-delivered verdict.
I am honestly disappointed in today's proceedings and everything in court. By the judge, as I understand as a layman, hiding behind the constitutional issues that were raised by us, the petitioners, blah, blah, and saying that he had dismissed the case. But with that, for me, I have said and I continue to say, today's judgment or ruling has made me lose a lot of confidence in the courts again.
But former NDC chairman for the GHOne constituency, George Ani Bansa, told GHOne that they will appeal the verdict.
Article 11.7 says that anything that becomes law in Ghana must be laid in Parliament same day and gazetted same day. So here we are. We have the CI 128 laid in Parliament somewhere in July, according to the evidence of the CI 128, and gazetted in gazetted in August, when Parliament had already risen. So this is a clear act of disregard to the rule of law, because what does not exist in law cannot be taken to the Supreme Court for interpretation.
Today definitely is a bad day for the petitioners and of course the NDC here in the Volta region. But this very issue would definitely be top of the discussions as we head into the 2024 elections, particularly in the GHOne constituency. Reporting here from Ho and for GHOne, my name is Faisal Abdul Idrisu.
Yes. That's the man, Faisal Abdul
Idrisu. So today that he said was yesterday.
Okay.
Yes, so that was yesterday at the whole High Court. So the petition has been dismissed. So the petitioners will have to take the next step in relation to that. So that is how far the SAR incident has gone. In fact, 2020 is just along the line. I hope that everything has been done for them to vote. So yesterday also, at the High Court was the
anti-Gabriel hearing.
This particular leg of the anti-Gabriel, in fact, it was one of the cases that has been first televised at the High Court. Justice Ellen Sewamreku's court. And yesterday, what was to happen was that the court was expected to fix a date for judgment after the parties were given time to file their written submissions or their written argument. Instead of coming to court to do oral submission, the court, they put everything in writing, bring it to the court and to be adopted, and the court would depend on that to deliver its judgment. But unfortunately, the applicant who was supposed to file first, and then after that, 4 weeks later, the respondent, the Speaker of Parliament, and then Attorney General will respond to that, which was supposed to end, and the court would fix the date yesterday. They didn't file. They only filed last Friday, out of time.
Okay.
They apologized to the court, and now Justice Sewamriku has given them up to October 22nd, that is certainly the new legal year, for mentioned, and if everything is sorted at that time, the court will now fix a date for its judgment. So that's what happened in relation to Paul Boamasepa, a farmer who is challenging, looking at the processes in which the bill was taken through. His contention was that it had an impact on the consolidated fund, and proper due diligence was not that, so the court should look at that issue for him. So that's what happened in relation to that one.
To that particular case. And then the recruitment scam.
Yes, so this case became, it was everywhere, in fact. So a military officer, Captain Abel Nate, in fact, it was a subject matter of bench warrant. Then the military produced him in court. And interestingly for him, he was charged with conspiracy and defrauding. Unfortunately for him, prosecution says that they have conducted investigation, and at the end of the investigation, they realized that he had no idea he's innocent as anybody, but rather the first accused person used his name to scam people, allegedly. So for now, prosecution is saying that investigations are concluded, and they say that Captain Abednate is innocent. So their prayer was for him to be discharged. So his honor...
Was it granted?
Yes, his honor. Once he had no connection to the crime, he was discharged by the circuit court. So Captain Abednate is free now. So he walks home free, as the prosecution indicates. So he is the man in white there. Yes, one of the movement in court. So he's free. He has been discharged. So he's no more part of that particular case at the circuit court. So that is what happened in relation to that case.
The recruitment scam. Now let's talk about the ambulance case.
Yes.
Remember last week you talked about the fact that it will be heard Monday, Tuesday, Wednesday.
Yes, Monday, Tuesday. So yesterday was Monday. Yes, it came on. And you can see on your screen. Yesterday, that was how the premises of the law court complex was looking like. You see the men in green, a lot of soldiers there. So that is the chief of defense staff in the middle, the CDS and the team yesterday when they arrived at the High Court. In fact, he came to testify as a subpoena witness for businessman Richard Jakpa. Yes,
maybe you're looking into the future.
So yesterday's testimony was very interesting. What lawyers of Mr. Jakpa sought to portray is that if you look at how Mr. Jakpa was released, they are saying that he was released because of his disinterest in the military and not based on fraudulent activities. So the military was in court. Also misconduct. So the military was in court to come and point to the regulations. And particularly what they indicated was regulation which pointed 2A. And at 2A, it didn't mention anything about fraudulent out of misconduct. So that was made clear. However, he indicated that apart from that, there are so many things that go into it. So if you look at that one alone, you will not get the picture. So Mr. Jakpa was released dishonorably. That is the reason why he cannot even use his military title as a civilian now, because of the manner in which he was released. And I also made the point that, look, he did not release any letter. He didn't get any communique for release of any confidential letter on Mr. Jakpa to the defense minister. So how the defense minister got it, he has no knowledge about that. So these are some of the things that Chief of Defense Staff was telling the court yesterday. And in fact, he was cross-examined and discharged. So now he's done with. Today, you mentioned that, yes, yesterday was Monday. Today is Tuesday.
The case continues.
Yes, so today, the court presided over by Justice Ifeanyi Saributri is expecting some more witnesses. It is not clear who is coming, but then an officer from the Comptroller and Accountant General Department is the one that they are hoping to come. In fact, the subpoenas have been served because of the plan that was distorted last week. So it made it very difficult for some of the court to even know who and who were coming. Because last week, some of them came and they were told that the court was not sitting. So it was difficult. But what is clear now is that today the court will sit, hoping that witnesses will come in relation to this very matter. So we expect Mr. Jakpa's third witness to appear today at the court. Yes.
Okay. As you talk about cases today, this particular case has another leg. That's the submission of no case.
Yes, it has another leg. Remember, when prosecution closed its case after calling 5 witnesses, the lawyers of the accused person indicated that no prima facie evidence has been established for which reason they have to be called upon to open their defense. Justice Efia-Sewa Saribotwe ruled that prosecution has made a case through the witnesses that came, and so a prima facie evidence has been established. Therefore, they have to open their defense and respond to the charges, which we have seen it happen. They are doing it right now. However, they filed an appeal against that decision for them to be called upon to open their defense. And today, 3 wise men, because they are going to the Court of Appeal. And the Court of Appeal today will be delivering a decision on that ruling made by Justice Efia-Sewa Saribotwe as to whether or not there was a case for them to cancel. And 2 things, one of them will happen. If the court is of the view that there's no prima facie for them, they will be left go. Okay. So whatever will be happening at the High Court will be truncated. But if the court held that that is it, then it means the continuation of the case will happen. These are the 2 things that we expect to happen in the ambulance case. Today, the witness will come. At the same time, the Court of Appeal will be making a decision on the submission of no case that the court made for them to open their defense at the High Court.
Today also, we understand the ANAS number 12 expose case will also be in court.
Yes, so one of the reasons this very case has stalled, if you ask me, in my opinion, is because of a ruling by Justice Marie Lewis Simon. The court's ruling was that ANAS will have to be in court because it's a witness for the prosecution.
To unmask.
Absolutely. In chambers. For Nyantechi to see that, yeah, this is ANAS, this is you, this is the person who is coming to testify. And not on once. At any time that ANAS will be in court to testify, you will have to go in chambers or masked, and you know that it's the same person. Then you come in open court masked. They say that ANAS is saying that even that borders on security and he's not safe. Even the police officers who have been attached to him as people who are supposed to give him protection have been withdrawn. So now he's on his own. So security-wise, he doesn't feel safe, so he's not coming. Prosecution is appealing against that, and today, the Court of Appeal will hear that particular request, seeking to reverse the High Court decision for ANAS to unmask Nyantechi in chambers, but unmask in open court to testify. So today, the Court of Appeal will sit in relation to this one. And this is the reason why the ANAS Nyantechi case is delayed. The court threatened a couple of times to discharge them when the prosecution is ready. But the court at the same time is saying that let's wait for the outcome of the appeal. So today we'll have an update in relation to that case. Yes.
And then the injunction against the Gen Z demo. This injunction, yeah.
Quite a while ago,
we were talking about Gen
and
Zs,
the group talking about Gen Z. So protests against economic hardship, you know, some people, some organizers, they think that ASEPA is one of them, Arise Ghana, but as Mona and the squad, they are saying that, look, there are a lot of hardship in the system and they want to throw in the street. In fact, it is tomorrow that they earmarked this demonstration to happen, a whole week demonstration. The police said, no, we are not satisfied with the plan. We have asked that you make some revision. You said that you are not doing it. Then let's go to court. So the police has filed an injunction at the High Court seeking to stop them from the demonstration tomorrow. And before the High Court today, the court will be hearing that particular injunction application filed by the police. So this is one of the cases that we should also expect coming. So a lot are happening in court in relation to what is coming up all day today.
Okay, yes. Captain, thank you very much, as always. Catch you on the flip side.